So this is great. Thank you for having us all here. Thank you for this great panel of former and current SEC people. This is going to be good. We're going to jump right into it. And this is for all the panelists, since we've spent probably about 3 or 4 hours not preparing together. You should all speak up and ask anything you want while we're talking. So I have, we'll start with David, because that's why everyone's here, and want to understand what's going on in the enforcement program. We can save exam for later, but what's going on in the enforcement program, what's going on in the Fort Worth office, and what's going on at the SEC?
Well, great. Thank you, David. And I also want to give a big thanks to Mark and Brooks and Natalie and the other folks at the Texas Law Book for the invitation. I do look forward to coming in and talking to this group, and I really like talking shop with the folks that are up here today. So this should be a lot of fun. And before I get started, I'll give my standard disclaimer that the remarks I make today reflect my opinions and do not necessarily reflect those of the SEC, the commissioners, or the other staff of the SEC. I think if I was going to give you the nickel explanation of what we're doing, I would say look no further than our rulemaking. We have done so much rulemaking in the last 2 weeks, but at least proposed rulemaking in the last 6 months, that is really what is driving the commission. And that, by extension, is driving what we're doing or thinking about, at least on the enforcement side. So kind of the big picture items, ESG, principally climate change related, SPACs, cyber, crypto, those are kind of the big picture items that we're focused on from an enforcement side. When you take it down to the local level,
which is nice because you're also focused on those from a rulemaking side.
Absolutely.
So you can make rules by enforcement.
Well, we don't do that. That's why we're that's why we're doing. See, you get mad if we bring cases when we supposedly don't have rules, and now we're putting in rules, and everybody's mad that we're putting in rules. Yeah, so they're just mad. I mean, that's the way it works. I get it. But if you drill it down to the local level, I mean, our docket generally stays pretty consistent, which means offering frauds, accounting fraud, insider trading, and then a variety of regulated entity cases take up probably 90% of our docket locally. But, I think what we're going to talk about are a lot of the big ticket items. Happy to drill down on some of the others, but they don't really change year to year. I mean, offering fraud is offering fraud. If I had to say my prediction, it's that I'll probably start seeing more oil and gas related offering frauds, if only because prices have gotten so high. And kind of, if you've done this for a while, there's about a 6 or 9 or 10-month lag between a really steep increase and then people start reporting that, hey, I'm not getting paid on this investment I made 6-10 months ago. So that's the only prediction I can probably make. But that's really what we're doing in a nutshell.
How about financial reporting cases? A lot of things going on there.
Well, I would say nothing different from what has been. I think, and we can talk about this more, the whistleblower program has been such a big boon for the agency in that respect that we kind of have this constant flow of cases, and at least that we're investigating. I think in terms of specific issues, there are none that just jump out as particular issues away from, other than perhaps in the SPAC area, the disclosures around SPACs, either when they make that de-SPAC conversion or in their post-SPAC life. But I think that may be more specific to the nature of those companies. In particular, you have a lot of those companies they're pre-revenue, they're certainly pre-earnings, they may even be pre-product, and they're still coming to the public. And on the basis of a lot of projections, a lot of pie in the sky of where we're going to go or we think we're going to go, they get public. Suddenly they're having all these problems. They're having to restate. They're having to revise information they put out previously, and that's spinning out enforcement investigations. So, but aside from that, I think it's we're just seeing kind of the steady hum of the kinds of revenue recognition and disclosure cases that we've traditionally seen.
Do you think the steady, I would say, increase in whistleblower reports, do you think that you sort of have to investigate those, right? I mean, most of the time they're not really optional, and they tend to be better than just your standard TCR. So do you think that clogs up or takes resources from the enforcement staff?
No, I think it's kind of in the opposite direction. And there, because I would kind of put whistleblower complaints into two buckets these days. Now, if you could go back 10 or 15 post, right after post Sarbanes-Oxley, when whistleblower complaints are actually flowing through the Department of Labor and then coming to us. And there, if you found one in a 10,000 that was worth pursuing, you were lucky. Now, whistleblower complaints that are being shepherded by the fairly large and growing bar of whistleblower lawyers tend to be pretty solid, if only because you have somebody there who's probably has the experience, maybe been at the SEC, certainly has experience of what kind of cases we're interested in, and are able to distill down to what's important, what they know will be important to us, and bring that to us and kind of let us, instead of starting at square zero, we're starting at square three. And so we're starting farther down the road on those. Now, the general, I read something in the paper and I'm angry and I'm sitting and I'm a whistleblower. Okay, those are things that have to be dealt with most likely at a TCU, at the triage stage. But the other kind, I think, really, we take pretty seriously. And we've now have enough experience as staff to know if we get something or if we get a call from such and so lawyer or law firm, what they're calling to tell us is probably worth at least looking at. It may ultimately not be a case, but it's worth looking at.
What about the new, they're not new anymore, I guess, the division director, all of that's settled now, right?
Yes.
So how's that? How do they work? This is a chance for you to say something nice about your.
Well, yeah, I mean, I think
Recorded.
I think anytime you go from uncertainty or kind of, an acting person to where you're not exactly sure what will be the policies in 6 months to somebody permanent, that's a definite improvement. But I think one of the other things we've seen is Gurbir Gurwal, who is division director, very experienced, very certain of himself. He has a lot of confidence because he was an elected, official in New Jersey. So I think he's very confident in what he wants to do. And then his deputy, Sanjay Wadhwa, was a longtime manager and attorney in the New York office. And so from my perspective, it's nice to have someone from the region, in a senior policy position in Washington. But also Sanjay just knows a lot of stuff, and they've made a lot of changes. The agency, and it does this over time, decentralizes, centralizes, decentralizes, centralizes. And we're kind of coming out of a period where everything was centralized in Washington. And so any decision we wanted to make on a settlement or a recommendation, or how do we deal with this, request to extend extend a tolling agreement, were things that we had to run through Steph and Steve. And that's not bad. They're certainly knowledgeable people, but it just creates a little bit of a vacuum in the regions. Sanjay and Gurbir, I think, have done a good job of starting to push some of that back out. One of the first things we saw was pushing back out to SOs the power to approve formal orders. Now that has since been pulled back in, but someday maybe it'll get pushed back out. But there are other things along that line, so I think, by and large, I feel like we're in a really good spot as a division in the balance of home office authority, regional office authority. We can make decisions and feel more confident. You can hear from us making decisions and feel more confident that's actually going to be the answer, and that's a good thing in my view.
So Rebecca, you're recently out of the agency. How's it going? What's it like? Is he telling us the truth? David's an honest guy. I trust him, but
yeah, he said
no
longer my
here.
boss. I was joking that I think everyone up here I reported to at one point during my 10-year SEC career. But now I can, be really honest now that I'm out of the reporting chain. I don't have to give the SEC disclaimer. No, I'd say so. Private practice is great. I really have enjoyed it. I got so much experience and, knowledge during my decade at the SEC that it's been really rewarding already to be able to use it. And I will say, I think it is good for, the staff and the enforcement program, of which I'm still a large general fan, is that it's good to have experienced and knowledgeable counsel on the other side. Like it's better for everyone. It's better for the clients, better for the staff. It's better for the efficiencies of enforcement. It lets you move through investigations that should be closed more quickly and lets you get to a result of one, that should be brought. Kind of on a personal note, it's been really fun reconnecting with lots of, friends and legal classmates and things like that. Because for whatever reason, none of my GC friends wanted to be like besties with the SEC enforcement lawyer. So it's been fun having them actually want to talk to me again. So yeah, it's been fun. And there's a great kind of post SEC bar that has been wonderful to be a member of.
Actually, I have to tell this story because what you just said, people think, oh, it's a joke. Who wouldn't want to be friends with you for an SEC?
No one.
I remember going one night to one of my sons had something at school, and I sat down at the table, and there were like 6 people there, and we started talking, and somebody said, what do you do? I said, I work at the SEC. About 10 seconds later, this lady got up and left. So about 6 months later, her husband called me, and he said, oh yeah, his wife, she said, there's no good that can come from me sitting at this table. she was an investment advisor. I was like, what does she think I'm going to do? Anyway, so that is actually going to be true.
They asked, who invited the narc?
I don't know. It was like,
Exactly.
really hurt my feelings, actually. Anyway.
You don't have feelings.
I don't. That's true. So what about? So you've been out. So you're talking to a lot of people. I'm going to ask Rebecca again another question. You're talking to a lot of people. They want to get your perspective. What do people care about? What's going on with like your clients? What are they asking about? And you don't have to tell us their names, obviously.
Yeah, I definitely won't do that. My GC of my firm is sitting here.
That's why he's here.
I still have to give the disclaimer, I guess. No, so I'd say it's been interesting to me what a mysterious agency I think the SEC still manages to be. I mean, everyone I've met since then at conferences or client events, I mean, they all just want to talk about, how does it work? How do you get cases? How do you decide what to pursue? Who decides what to bring? They really seem, it's like a constant career day speech that I'm giving about, my prior job. And there's a lot of interest there. And I think, the SEC is a generally well-regarded agency. And so they want to know how that process works. I'd say from the client perspective, it's less about, how it works generally and how's it going to work for me. There's a lot of questions about fact patterns and at what point does that give rise to a reason to reach out? When should I expect the SEC to reach out to me? Will they reach out to me? What should I do? Should I touch them? Should I go out and tap them first? And, there's a lot of, very real world scenarios that, give rise to this whole decision tree. And it's interesting. And, it's a lot of responsibility on the private side to, talk through those issues, because there are a lot of things you can do on the front end that can be really helpful. And I do think the SEC is, pretty active right now. But, a lot of it is predicting the future. It's pretty much what's expected now that I've left.
Jessica, Rebecca said they're active now. Are you seeing that? Is the SEC aggressive right now, or as aggressive as you were when you were there?
Yeah.
Yeah.
Next question.
That's it?
No, it's really hard to keep pace. The thing that I keep finding myself discussing with my clients who are universally innocent or at worst misunderstood is that it's when you are engaging with an agency, and right now it's more than one agency. If you're dealing with the SEC Division of Enforcement, I think you should assume you're also dealing with DOJ, even though Jason Rose and those guys in the back are not going to tell you if you're also dealing with the DOJ, which is totally unfair. But, I think what we're finding is when everything is a priority, what really can be the priority? And so trying to keep pace with the speed of rulemaking, the implications for rulemaking, if and as adopted, the comment process, and what that means for clients right now. It's just coming up a ton in the cyber ESG space, where those two things meet. And you've got public company leadership, boards of directors that are wanting to make sure they've got sufficient expertise at their meetings, really wanting to know, what does it mean today and what's it going to mean for me, in a year, 2 years, 3 years. And to Rebecca's point, as much as we can draw on experience, you can't predict the future. And so we're spending a lot of time talking about something Marshall Gandy would like to hear me say, which is the importance of compliance and really empowering financially and through resource, like people resources, your compliance function, your legal function, noting the up the ladder discussion that's apparently back on the table. I think in-house counsel and compliance now more than ever really has to have a seat at the table, because I think everything's on the table for enforcement. Truly.
So you said a bunch of good stuff.
Well, that's what I do.
Keep talking, yeah, you keep talking up, yeah. So
If I talk enough, my husband says I already do.
So actually, I have not read this, I will confess. I've only
Okay.
read a summary of this.
It's
It's like 20
around-
pages long with lots of footnotes, and I'm not, anyway,
We
but
don't bill by
this,
the hour anymore.
send lawyers, that is true, send lawyers guns and money, overzealous representation by corporate lawyers. This is Commissioner Allison Heron Lee's statement. David, I assume you've read this. Is this a huge problem? Do you see the problem she's describing here in overzealous corporate counsel? I don't want to put you on the spot here.
Walk a fine
Yes,
line
you
here,
do.
but look, it is a statement of policy or belief by a commissioner. It's not yet
Right.
presented as rulemaking, anything like that. So she has her perspective. I do think there are situations, and we see this with, I don't know if it's more frequently or less frequently, with transactions that are coming in and someone says, well, I ran it past the lawyer, or I ran it past a lawyer. And so I feel like we're seeing the advice of counsel defense, if not floated formally, floated at least kind of informally, very frequently. And, invariably that opens up a whole nother line that we have to pursue. Sometimes we have to wait till we actually file the case and it's more formally asserted so we can get a judge to order them to present the lawyer. And a lot of times you find out, well, no, the lawyer just happened to be around or was advising on some other issue. And we've been successful in getting that excluded by and large where it's come up. But it does create a real question of, okay, well, let's say a lawyer did approve this. How? How could they, in the understanding of the law, have decided this was compliant? There are probably gray areas, and I don't necessarily want to debate all of those. I know there's what she's talking about, a lot of space is around cryptocurrencies and things. And that's look, I don't know, that's a very challenging debate to wade into.
Yeah.
And I see Arnold here, and I'm definitely not weighing into it with Arnold, but it is, that may be to me on the least end of this, the least troublesome end of the spectrum, where you're trying to divine the law in a very gray area. There are things we get thrown at us that I just like to go, how could you possibly think that was legal? And that's where and then there's no recourse for that.
But isn't that the exception? I mean,
Less so than it was.
well, I understand. There's a policy though for when a client, a investigatee comes in and says, I relied on advice of counsel. There's a process within enforcement, sort of to walk that critical path and figure out when you're going to ask for waiver, when you're not. It's a different issue to say, okay, lawyer, inside or outside of a company, we think you may have been involved in this. We're going to road test what you did or didn't do. I mean, to me, that's crossing the Rubicon.
And look, I've been on both sides of this in recent history. And so I understand the idea that, as a lawyer, in my case, for investment advisor and broker dealer, you're making decisions every day that may get somebody at the SEC unhappy with you. And you do try to do the best you can. And historically, the way we've looked at it is, so long as you didn't violate kind of your state ethical rules and things like that, or weren't an active participant in a fraud, you tended not to have any consequences as the lawyer. And I think there is just some frustration. I think it's boiling up through Commissioner Lee's remarks that there should be consequences where those lines are crossed, because there aren't right now. I mean, the number of cases, I can't even think of a case, unless it's like an opinion mill type lawyer in a penny stock case, where we have gone after a lawyer for kind of facilitating wrongdoing. Now, I'm not saying that's something we should, in my view, that's a really tough place to go. And I don't know where this will ultimately go. So like I said, I don't know where, this is her view. I don't necessarily share it to the same degree, but I understand the frustration that she's expressing.
So lawyers can be problems, but accountants are well respected. So Steve, let's talk about accounting. Um, are you
Finally, the lively part of the panel?
exactly? I'm going to ask you about financial reporting. Are you seeing activity in that space? Because, since the fraud task force, I think, went away, the cases have come down.
Mr. Woodcock was in
Yes,
charge
thank
of.
you very much. But it doesn't seem to be as much activity, at least in terms of numbers, but that doesn't mean there's not a lot of investigations. But what's the accounting world look
Well,
like?
I think a few things, right? The schemes don't change. The vehicles by which they're executed through, they change, right? And so what is sort of old is new, right? You see the same kinds of Ponzi schemes and offering frauds and even the financial reporting frauds. It's the things that investors care about, right? That's what you see that's being manipulated. That's why it's being manipulated. So as far as like case counts and things, we've seen an uptick. Now, what is different maybe is the days of, or at least most of the days of large financial frauds involving, swaths of people around hitting EPS and those kinds of things. It's about refinement, right? You won't see as many of those. You see much more things around refined measures, around, particular metrics, but it's the level of departure, if you will, is less, right? That doesn't make it not a violation. That doesn't make it not a reporting problem. But we've seen a lot of the cases the commission has brought bring in other charges that if you go back a decade wouldn't have typically been brought, right? Internal control charges, right? That used to be like, if you can't have a 10B5, you'll settle for a 17A, but forget doing anything that just starts with a 13, right? And so that's not the world we live in anymore, because it gets back to a shift that happened years ago. But I think under this particular chair and the director is continue to push compliance being a very important thing, and books and records, internal controls being primary violations that they care quite a bit about. And so one of the things we're seeing is around individual accountability, an uptick in individual accountability, but on things that would not have been cases in the past. So for instance, an auditor case with a manager who's a year being a manager, right? Typically that would have been, well, he's new to the job, he's transitioned in. Now it's a much more different world, strict reading, right? He knew, he didn't tell, right? And so
What do you do? So what do you do in those cases if you're representing that person? What do you do?
Well, I think this is going to get into something I'm sure we're all going to talk about precedent and lack of precedent. Historically they hadn't brought cases like that. So when you look at, for instance, manager case and an audit case, unless they didn't tell the partner, material facts, they generally weren't held liable themselves, right? Because the partner has all the responsibility and supervision standards. You can go through all the audit framework. It has moved to look down to individual responsibility, even downscale to earlier in career professionals. Now we can all have a discussion as to, is that good policy? Is that bad policy? Right. But there has definitely been a move towards individual accountability in a more granular way. So maybe you told them 5 facts, you didn't tell them another 5. Well, then you didn't tell them everything, right? Historically, it would have been, well, you conveyed something, and given your tenure in the role and other things, not that you were given a pass, but there was a more understanding view of things. I think it has moved towards a more, I don't want to call it strict liability, but a more strict liability kind of framework.
So as an accountant, you feel like the accountants are getting the accountability that the lawyers aren't.
Well, if you look at charges, right, because there's 2 different agencies looking at auditors, right? One looking at financial reporting people. Accountants get charged way more often than lawyers do by a long shot. And they're under far more scrutiny, because certainly auditors are getting their work scrutinized by the PCAOB. Financial reporting get it scrutinized every year to 3 years by Corp Fin. So there is a different level of sort of known responsibility and accountability that's required of them. And so there is greater investment in compliance, because if you really think about it, decision making is getting accelerated, right? Think about when an internal investigation comes up, you just assume it's a whistleblower nowadays. And so now you have to make decisions about who's in the rep chain or who's in the internal control chain that you have to do something about, because you're not going to get any credit if you don't do something early. And so you take on risk, both as in my role advising counsel, but counsel advising a client about, hey, you need to take them out, because if you don't get them out soon enough, you don't get any credit for it with your respective regulators. So you have to make decisions earlier to have unintended consequences if you're wrong, employment lawsuits, other things like that. And so it's challenging, because you have to do that to get credit nowadays from a standpoint of cooperation. At least that's what I'm seeing.
Were you going to say something, David? Agree.
No, but I do think the point, this is the difference in some ways of having a really detailed set of rules
Mhm.
that you can trip up at all these different points, and then that being lawyers where you don't have that same book of rules. It's harder for us as a regulator to say, this is what you violated when they're very, drawn very broadly. But
Lawyers
you're
have that up the ladder rule, David, just because it's never been enforced, doesn't it?
true. It's true. I think it's there. We'll
It's
see
there.
what if it elevates from being there.
And I would say what Steve just said about the, controls and compliance environment. In the last 4 actions I brought at the commission, 3 of them had controls, charges, including even like a Nikola case. It was this huge fraud case. It's 10b5, it's, 17a, and it's disclosure controls and procedures. It's still looking at that. Just because there's a big fraud to point a finger to doesn't mean the commission or enforcement is not also looking to how did this happen? How did it come up? Charging the procedures or lack thereof that allowed that to happen.
Is it the case that in every fraud case, you'll have a disclosure or an internal controls problem? Because your
You should
internal,
assume it.
but your internal controls aren't really necessarily going to prevent all frauds. They're not even required to. They're supposed to provide reasonable assurance or whatever. I mean, they're not so.
But that comes up in how you're framing it. So if you're engaged with the staff, if you're in an enforcement environment, it's the lawyer's job to be framing it that way and driving that level of conversation that an internal compliance, internal controls environment is not meant to be perfect. Perfect is not the goal. Reasonableness is the goal. Good faith is the goal, but you still have human activity, sometimes rogue actors, sometimes intentional bad acts, sometimes reasonable good faith mistakes.
But
And
then you're
that's
pointing
the
the point.
advocate's job.
But then you're really pointing
But
the finger
and
at an
that's why I think
individual
you have to assume, I think anytime you're dealing with enforcement right now, I think you have to assume that at least a discussion about the controls environment has to be had. And when you take it to a place of, what does it mean for cooperation? If you're not having that conversation from the outset, you're not doing your job.
Mhm.
But from a practical standpoint, if you're dealing with a fraud case, whether it's settled or litigated, the 13A charges are like the last thing anybody.
Yeah.
And
I know,
and
I
they
know, yeah.
invariably get dropped into any settled case.
Yeah.
And any litigated case, because we got to win on something. If we don't win on fraud, we at least can win on the 13A or 13B charges. But I do think one thing, this office and Rebecca, in fact, was one of the people in this, our office has been pretty active in the standalone controls case. Going back to a case that was generated, speaking of the fraud task force, Magnum Hunter was generated out of the fraud task force, which was a pure ICFR case, all the way up now to Tandy Leather, which was last year, I think. Yeah, something like that last year, which again was a pure controls case. And they are important. And the reason, some years ago, Mary Jo White, when she was the chair of the SEC, used what I think of as the very unfortunate term broken windows. And she threw that out there kind of as a coverall for all of these non-fraud charges. And it made it sound like they were ticky-tacky or really just technical gotcha violations. But the problem is that's a bad name for them, because what I think about it is if you have bad controls, they either do lead to a misstatement that maybe is not fraudulent, or they will, or they certainly could if uncorrected. And what we've seen over and over again with restatements that are material and significant to, say, earnings, is that does cause harm to shareholders. And that harm could be avoided if your controls worked. And that's really what those cases are driven at. Now, I will tell you, the number of standalone, controls cases that we bring is always going to be in the single digit range, simply because we don't have an appetite for it, unless it's like Tandy, just crazy. I mean, yeah, well, but now we won't bring any. But no, when they're just really, really egregious. But the reason is, again, the harm still exists even without fraud, and that's why those kind of kind of the plumbing, if you will, of financial statements is important for us to be taking a look at.
Although I'd add that Tandy did have a fraud charge against the individual,
I-
and so did ProPetro. Like, there's often
yeah.
still something.
There are still charges,
It's
but
rarely to
yeah.
have a truly standalone controls case. For that corporate entity, that's what was correct, and the individual faced the fraud liability there. But it really, and kind of supports your point that it is rare to end up bringing a truly standalone.
I don't think
case.
the agency has a strong tolerance for those.
Well, also usually, I think by the time it's been risen up and been, enforcement staff is involved, there's something that probably supports a fraud charge. I mean, like you're not usually seeing a controls violation at a company level that hasn't caused a problem that could be in the realm of fraud.
Those words will come back to you, Rebecca. When
Next one.
Can I get a
You're in the
copy of
Wells
this tape?
process.
No, I hear what you're saying.
I want
Changing hands.
to, so two other things to talk about at least. SPACs. Why does the SEC hate SPACs so much?
Don't hate SPACs. It's not what this is about. Look, I think in some ways it's the way they've been sold and presented is almost like a shortcut, to the public markets. And in some ways that's how they functioned. And if you listen to Gary Gensler, the chairman of the SEC, for any length of time, the one thing that he is always kind of his one constant theme is he wants people to have information, all the information that they need to make an investment decision. All these things we're going to talk about are really about getting information to investors so they can make an intelligent decision. Shining light in the darkness where
I'm being
so and
nice.
so.
I'm just being nice right now. But I'm not going to say material, right? He doesn't care about material information. It's just information.
I think
that
it's
fair?
Okay,
Okay,
but
good.
that was implicit.
Yeah. Okay.
So,
yes.
but on the problem with SPACs is, SPACs allow companies that don't have to show what their actual performance is into the retail investor world. And unlike an IPO, where they have to give all of this information about this is our actual business performance. And so it is putting a level of risk into the retail investment world, which really doesn't make a lot of sense. I mean, in all honesty, when I used to think about blank check companies, what do we all think of? Well, it's a penny stock. That's a vehicle for bringing some, crazy mining company to the public so we can manipulate it through a pump and dump. And then
But you're not
So
anti-SPAC.
cynical.
Yeah.
but that's just the history of blank check companies. But then they kind of took on this aura of legitimacy, and there are companies that have come.
Yeah.
That have
I'm
come.
noting all of them.
But I can give you an example. There is a company, and I hate to single one out, but there is a company that was involved in the office leasing business that raised billions and billions of dollars from venture capitalists. Went to do an IPO. The IPO hit the street and everybody laughed. And they pulled the IPO and the company shoved out its founder and
they made a movie about it.
they made a movie about it.
It's a television series.
That same company,
Yes, thank you.
that same
Thank you.
company
It's excellent.
came public by a SPAC. And I mean, their performance by and large of all of these SPACs as a group is poor. When real performance is shown or, to the public, they all go, huh, what are we doing? And that's, I think, it's not a dislike. It is, we've got to bring this playing field back together because it was almost like regulatory arbitrage, hey, this is an easier path to get companies that couldn't make it by IPO into the public markets. And I think that's what the agency is recognized as now proposing rules on.
So for others, I don't know, anyone else, I mean, what is this going to do to the SPAC market? I know you're not all transactional lawyers, but is this going to do anything? It seems like it's going to do something.
I don't know. I mean, I think that they have slowed down a little. But that said, I mean, I don't know that I would call it a shortcut, but it's a different avenue to the public market. And the IPO process is burdensome. I mean, if you are a pre-revenue company, whether or not, possibly David thinks you should be public or not, if you want to be, it is challenging. And the SPACs offer a vehicle to be able to do so. And I think there are, thousands of companies have gone public via SPAC, and many of them are legitimate companies that now having access to this capital can now execute on their business plan they couldn't otherwise have done without going through the de-SPAC process. That said, the SPAC process, it is short. There are a lot of incentives on, especially the sponsor level, to close a transaction that maybe you otherwise might have thought twice about, because you as sponsor lose your compensation if you're not closing by the deadline. The IPO underwriter is usually partially compensated at the time of the transaction. There's a lot of incentives that don't necessarily align in a way that, as a former enforcement SEC attorney, you necessarily want. That said, I mean, I think you can still do thorough diligence. You can solve a lot of these problems. Disclosure solves a lot of them. A lot of the SPAC proposed rules are already kind of best practices for the better SPACs that are out there, all of which are represented by Vincent Elkins. But I think there are good ways to do this. I think in a lot of the corporate attorneys I've talked to welcome many, not all of those proposed SPAC rules, because it helps kind of codify what they're already telling their clients are best practices, but their clients may or may not want to pay for when it's not yet required. And I think, that kind of transparency is helpful. Will it slow it down? I don't know. There's a lot of money in the public markets these companies want and need. I don't know that the fear of future enforcement necessarily slows it down.
I agree on the remark about, some rulemaking, some clarity, I think is a helpful tool for transactional lawyers to be good stewards of their corporate clients that really want to get public, but may not be mature enough. I mean, right, we want to see a frothy public company atmosphere when apparently private funds are also the enemy, but don't get there this way, right? Get there the other way. And so it's like taking hits from all sides. Yeah.
It's the Securities and Everything Commission.
But I think
Everything.
My David gets paid big bucks.
It's the Environmental
It
Commission.
won't fit on a seal though.
but it would go on a t-shirt.
Yeah.
But I think that's really the conversation is companies need to be thinking about, are we really ready to be public and all of the responsibility and obligation and expense that goes along with it? And they need good accountants and lawyers telling them a lot of the time, no, you're not ready yet. And I think that's where we've seen a lot of trouble on the SPAC side. Also, it was like, Beanie Babies when I was a kid and you were a teenager, just this incredible market
And
demand.
had Beanie Babies.
And incredible, because you were a nerd. Incredible market demand and then too little supply. And so you see this sort of scarcity complex and people making deals with companies that are just have no business, being targets. So I'm hoping to see a little more balancing out. But I think that mechanism as a way to become public exists for a reason and can be a healthy option when done right.
Well, I think as long as the economic incentives are there for a sponsor to sponsor a SPAC, I don't really see them slowing down much. I mean, there is not yet, well, there's only one, as far as to my knowledge, of an enforcement case against a sponsor. And so I think there's a little bit less liability there so far, and it is a little bit harder to draw, but there's an enormous financial upside to being a SPAC sponsor. I mean, I think the Stable Road case, which is the only one I know of that did have an enforcement action against a SPAC sponsor, but I think that was a really good. I was at the SEC then, so I can say this message to the market about being a SPAC sponsor. I think there, the allegation was not that Stable Road, who was the SPAC sponsor in this case that came out in July of 2021, it wasn't that Stable Road knew the target was lying to them. The target was lying to them, and the target was also sued for lying. But there, it was a negligence-based proxy violation that Stable Road did not do its diligence, because if it had, it should have, per the order, pretty quickly realized it was being lied to. That it was getting statements that did not even really pass the smell test, and it should have dug further. And I think and I'm sure there will be, more of those, and starting to build out what is reasonable level of diligence for a SPAC sponsor. When you're under this time, just because you're under a timeline doesn't mean you can't do thorough diligence, as again, all of our clients do. But, I think seeing something like that, where like, hey, that rush, that failure to even gut check if that claim is right, you can be held liable for that. And I think that is something that can help that market, because I think the sponsors have an important role there.
I don't think SPACs are going away, right? The market uses them as a valuation tool and a capital raising tool, and that's not going away in the marketplace. So it's going to be a SPAC or something else. And the rules are really get around two things, right? Aligning risk appropriately between the sponsor and the company, and disclosure. I mean, the 34 Act is a buyer beware market, right? So if the buyer is aware, that's your point about diligence and having time to do diligence and disclosing. You don't want to regulate to the bottom 5%, right? You want to regulate to
According to David, that's like the
well,
95%.
mitigate that risk. But the instrument in and of itself, that tool,
Mhm.
the market needs something like that to support, both exit valuation and innovation.
So another topic that we could probably spend a lot of time on, but we'll at least just raise it, is crypto or whatever digital currencies or whatever we want to call it. Jessica, what do you think about regulation in that space? Is it clear? Is it clear
It's
when something is a
clear.
security?
Yes, it's clear. We've got one regulatory rubric to understand. Done. So I think this, what did Gary Gensler call it? The wild west? Was it crypto that he was referring to? I think. And I get that sentiment, and I don't even entirely disagree with it. And I do a fair amount of work in the crypto space, but there's so much activity. There are so many innovative business ideas and business models, and there's just an incredible amount of risk. My first crypto matter was the SEC's first crypto matter, and I had heard about Bitcoin on The Good Wife. And so I raised my hand. I was like, yeah, I can work on that matter. I feel qualified for that. And,
I know what Bitcoin is, but I don't know what the good wife
it's
is.
been, yes, you do.
I don't-
Julia Margulies.
Don't
Well,
know
it was
who
a
that
great
is.
show.
Yeah.
You can
idea.
probably find it on any of your number of streaming services.
Really realistic view into lawyering. on
Yeah,
that.
yeah, they go to trial within a week. So, I mean, a lot has changed since, 2013, 2014, when we were just dipping our toe in that work, but a lot hasn't changed, right? It's still Howie analysis, and thinking about how the staff is thinking about it. So we're talking a lot about
strange, though.
exchanges now. I mean, I think even something was in the news today. I think the chair said something about taking a close look at exchanges, crypto exchanges, lending platforms, look at the BlockFi matter. So, there's so many more products and business models in the discussion, but I still think the discussion is somewhat what it's always been.
But it's strange because there seems to be the market saying we need more clarity on, and then the SEC saying there's so much clarity. What are you talking about? That seems somewhat unusual.
I mean, I feel like we're taking pot shots at you, and I really don't mean to. Okay.
We're all getting a
I have
drink
a list
after.
of grievances, so if you say feel free.
This was not intended to be a
I mean,
pot shot against David.
When a regulator says, sure, there's plenty of clarity, that's our way, right? Do it our way. So you
Mhm.
had at one point, and I forget his name now, I should remember it, but the gentleman who essentially said, Ethereum, not a security. And then that's maybe not the case anymore. And so it can feel a little whipsawing. But I find myself regularly talking with clients saying you should not design your business model around what you think the Division of Enforcement may ultimately say. That's not typically a revenue-friendly process, especially in the crypto space. So when working with clients that are involved in crypto or they want to have crypto as part of their overall business, I think it's just really important for enforcement-like lawyers to be working side by side with the corporate and transactional lawyers so that you're figuring out how to design a compliant where there is guidance and regulation, and a hopefully reasonable and somewhat risk averse or risk tolerant, at least understanding your risk tolerant business model. But then you should be prepared, I think, that enforcement at some point is going to show up on your doorstep. It's just the world we're living in right now.
Mhm.
That's not going anywhere.
I mean, I think the thing, and again, this is a tough area to talk about. I'm not going to talk about any ongoing litigation, but I do feel sometimes like, it would be like if after the Howie case, people would come to the SEC and say, well, I don't have an orange grove. I've got an apple grove. Is that a security? And I don't have that. I have a pineapple grove. Is that a security? And it's like, you're not giving me guidance about apple and oranges and whatever variation of a theme. And therefore you're failing in your duty. And I'm not saying that's the case for all of these products, but we have a statute which defines security. We have a Supreme Court case which defines investment contract, which is the principal thing we're looking at. And we have hundreds, maybe thousands of court cases dealing with all these different variations of investment contracts, all little features, this feature, that feature. There is a body of law that I feel like is there for, the 95% case, like the usual case for lawyers and, the business people creating this to give guidance. And I do feel sometimes that what they're saying is, well, you haven't spoken about my variation of a cryptocurrency, and therefore you're not giving guidance. And I don't think that's fair, and I don't think it's accurate. I think there is, if I'm reading what the chair is saying and some of the other commissioners, not Hester Peirce, who has a different view, she does think the other way. But the chair is kind of the view that you should assume that it is, unless you can explain why it's not. And I don't think that's a bad way. If I was in your shoes, I might start from that proposition and say, what makes us different?
Yeah.
And is that really a meaningful difference? I mean, is this orange grows versus apple grows, or are we actually in some completely different environment altogether?
And I think there's just a lot more conversation now about not just, is this a security, but okay, if we assume that this digital asset is a security, is this person or is this enterprise acting as a broker dealer? Is this an exchange? And I don't think that conversation was happening, even a couple of years ago, the way it's happening now. And I think that's a really interesting place to be able to help clients as well.
I mean, if it's any consolation, and it probably isn't, but the people that are in charge of these decisions in our different organizations are really knowledgeable about this stuff. Gary Gensler taught a class on this stuff. So, I mean, it doesn't mean that he knows everything, but I don't think they're coming at it from a standpoint of ignorance or, looking at it like it's witchcraft. I think they're actually trying to apply the rules and the standards that we have to, an evolving technology, and to do so in as consistent a way as they can. Now, there's going to be more rulemaking, and that's good, I think. But it is, I do feel like the people who are in charge of this, and they're not me, are knowledgeable and coming at it from the right direction.
Well, and when we were working on the first few cases together in the Fort Worth office, I mean, maybe I was just really ignorant. Many people have said so, but thinking that, well, what is this Bitcoin? We would go talk with other agency offices about what we were learning about it and how we were thinking about it. And it almost felt like I thought about CDs, like, flash in the pan, cassettes are here to stay. Like digital currencies, cryptocurrencies, they're not going to stick around. They're here. The blockchain technology is here. Decentralized finance is here. That's not going anywhere. And I think there was a period of time where we're like, okay, is she going to stay at the party or is she going home drunk? And it's here to stay. And so I think regulation is still
I tell
catching
you,
up
the
to it.
analogies that I get whenever I'm on a panel with her are always
It's like
so
it's
different.
1989 all over again.
I'm not even sure the CD
Beanie
works, given that
Babies.
my kids don't know what that is. Yeah. Say CDs are flash in the pan too.
I know I dated myself a
You
little
did.
bit, but the gray hair probably started that conversation sometime.
I think Beanie Babies did that.
I'm taking hits.
I've been trying to delay talking about what I really want to talk about, which is I have to believe, almost unprecedented rulemaking that's going on. But maybe we should just talk about that. So after Dodd-Frank, understand there's a 3,000-page piece of legislation. After Sarbanes-Oxley, understand lots of legislation, lots of requirements. Neither of those exist now. There's no legislation anywhere. And yet the rulemaking is got to be at the level that it was after both of those pieces of legislation.
I think even beyond that.
More.
I mean, in all honesty, that we never finished the Dodd-Frank.
And so I think one of the pieces of rulemaking has come out of, was finish up Dodd-Frank. I believe it's just one, maybe two, but most of it's not. And it regulates everything, private funds, private equity, shareholder proposals, cybersecurity, share buybacks, 10b5-1 plans, obviously climate. Which
When
we
you can
talk
wear
about.
white before or after Easter?
I would like some clarity on that, I have to say.
SPACs we just talked about, universal proxy access. And I'm sure there are some that I'm forgetting, but just give us some insight into, well, let's start with that. Insight into what is going on. Like,
Well-
not a lot of rules and with no legislative mandate. That's what I'm curious about.
It's an I think you have to maybe go back. If you look at Gensler's time at the CFTC. If past is prologue, then, he was engaging at that agency, leading rulemaking, which expanded their regulatory reach relatively far greater than this does in a lot of ways, considering what it was. So I think this is his view of what an agency should be doing. In other words, I think, and I'm not going to speak for Gary Gensler, but I think there is an idea that, okay, there are voids in the securities laws, and some of those voids we've known about, some of those are policy driven, some of them we learn about when, we have a meme stock event that nobody's ever heard of before. And we need to address all of those. And we're going to address them by rulemaking, as opposed to what we've been accused of in the past, bringing enforcement cases using our existing tools to fit into new or maybe patterns that weren't anticipated when those rules or statutes were originally enacted. And so I think that's a lot of what's driving it. But I'll go back to, the one common theme through most of this, leaving aside maybe some of the plumbing, the markets stuff that we're doing, I really do think Gensler's rulemaking views are driven by the idea that there's all this stuff going on in the dark. You got dark pools, you've got dark markets, you've got, you've got, well, dark web, but we don't really, that's not the same. But you've got all this, no, I appreciate it. But you got all this stuff that's going on out of sight of everybody. You take payment for order flow as a good example. Everybody kind of just assumes we're getting best execution out of that just because, but nobody knows for sure. And I think his view is that's like the opposite of what the federal securities laws are supposed to be about. The federal securities laws, when they came to being, were based on the blue sky laws, who got their name from the fact that you're shining light on stuff. And the first chairman of the SEC said, we want to level the informational playing field so people can feel like they're making an intelligent decision. And I think Gary is a firm believer in that. And all of these rules are designed, and not all, but the vast majority of them, to bring things that are currently in darkness out into the light where we can all decide whether they're a good idea or not. Now, some of these, look, I get it. Standing up a new reporting regime for climate change related is not going to be easy or necessarily inexpensive. It is a change, a major change. And I think reasonable minds can differ on some of the, maybe the margins. Mm-hmm. But where I keep coming back to is the idea that, there was an idea that, well, none of this stuff matters to investors. And I think that is absolutely demonstrably untrue. And I don't think we have to look very far, and I'm not picking on Exxon, but there are
totally picking on Exxon.
Climate change, ESG related investors who have enough power to put people on boards of major companies. That suggests that investors care about this stuff. And if that's true, then we need to be getting information to them on these issues. Where the lines are, let's see what the rulemaking takes us. But it's information that is important to investors. And our job as an agency is to get investors information that they care about. So that's what I think is a lot of this. And frankly, I would think in some ways we should get credit for trying to do it out in the light. It's not in back rooms. It's not through whatever you think of no action letters. It's not through kind of the arcane rules and things that we do with experienced securities lawyers. It's out there for everybody to comment on and send in, a diatribe or send in a praise or whatever you want to do. It's out there for everybody to see. And I think that's a good thing. Okay.
That was a wonderful combination of explanation. I think we all love regulation now. I think that's how I feel. More regulation, the better, I say. Yes. I should have said, if anyone has questions, you should just raise your hand. We'll save a little bit of time at the end, but for questions, just pop your hand up. So anything else? Everyone's happy with all the rules that are coming out. That's really what I'm hearing.
Well, the fear of being supportive here of what David just said is think about who the investor is now, right? millennials make up most of the majority of the workforce and retail investors, right? And so if you go back, think about like, in my world, segment reporting, right? That didn't exist 30 years ago, but it exists today. Why is that? Well, because, people my, whatever generation I'm in at 48, right? We want to know more about the business, right? So in some way, I think you're right. It's like and it'll change, 10, 15 years from now about what's important relative to an investment decision. But ESG and those kinds of things have become more important to make the allocation of capital decision, right? And so I just think that was inevitable. You can argue about when and how, and I agree with you about around the edges. It was going to happen because it mattered to the investment decision.
I think it's gonna be interesting to see how, where the lines get drawn on what is required to be disclosed, how the SEC is gonna, determine materiality on that, given that, I mean, that's just so much more of a qualitative factor there than quantitative, which is challenging. And there just seems to be such a reliance on expertise and expert reports that, just as a former regulator, I wonder how much of kind of an industry is now going to be created around this, creating these, the attestations, the reports that now need to be filed, and all of that, and how, the staff will be able to assess those. I mean, I know, for example, in Fort Worth, we have a geologist on staff that helps look at, production reports for oil and gas frauds. Here in the environmental area, it's kind of wonder where that will go, and how whether I as a staff don't know that I would have had the expertise to look at an environmental disclosure and say whether they, met the materiality threshold or not.
And I don't know what the answer is. I mean, I think it's going to depend on a particular company, particular industry. What are they doing? How important are some of these things to their current business, their future business? I mean, I don't think they're completely riding on a blank slate. I mean, there are standards that have been put in place internationally. There are standards that are applied domestically with the EPA. Companies that were part of that standard making, I think, understand it. I don't think we're not, this isn't fire in the dawn of caveman and we all go figure out what is fire. I mean, these are things that have been discussed and developed, internationally for at least a decade and maybe longer. So I think there are going to be some anticipated norms, but I do think it's going to be very company specific, circumstances specific, and we'll catch up, as regulators on what is or isn't material.
And this is going to be quoted against me later. I'd be surprised if enforcement's coming out swinging on this stuff. I mean, when the task force was announced, everyone was like, "Oh my God, ESG task force!" And then, there was messaging about what the task force exists to do. And I think there's been a lot of messaging about where the priorities are, and the materiality principles-based disclosure regime is still what we live with. And if the playbook that has always been followed of, we talk about maybe needing a rule, we make a rule, we prioritize something on the exam side, we have maybe an initial sweep on the important, and start messaging it to the markets. I mean, you see that. You see it with cyber, you see it with some of the early crypto cases. So frankly, that's what I'm expecting for ESG. The conversation I'm having is not, gird your loins, ESG enforcement is waiting around every corner. It's when you say you'd rather have a rule that you can read and implement rather than, regulation by enforcement, that's really what you're getting now. There's just a lot of it. There's just a lot of it. So.
Well, and I also think, and that's one thing we've talked about too, kind of in our client releases and disclosures, is that, for example, Nikola was a huge case that had ESG components, but at the end of the day, it was a fraud. I mean, it was a fraud case. And so
it was alleged to be a fraud. Yes.
Fair. According to the allegations in the complaint, it was alleged to be a fraud. And so I think as long as you are doing what you say you're doing, you're pretty good. You're most of the way there. The problem comes where a lot of these rules come into play is where companies are making claims that either are just completely not true, they're not substantiated, they're not documented, they're not updated. It's what the securities enforcement world has been looking at kind of from the start. It's, are you telling the market things that aren't true? I do think that is still the crux of it. There's just 400 other pages, but
it's going to be an expensive enterprise. I mean, yeah. The agency does not report on closed investigations. So however many things are tire kicked and closed, I don't get to know. shareholder book and record requests, shareholder class actions. I mean, the cost associated with hiring lawyers and others to say, we did do what we said we were going to do, is, incredibly expensive, not just in terms of dollars, but in terms of distraction. I mean, the mere receipt of a subpoena is such a distraction for the C-suite. Or should be, at least if it's being handled right, and sometimes for members of the board. And so it really is a challenge there. Is that sufficiently?
I'm glad to see there's some pushback.
Adversarial,
I've
I
found
know.
A table
Yeah.
full of apologists for rulemaking. I can't. Yes, thank you, John. So question, thank you.
Comment on private equity, because to me, I'm listening to you talk about, the idea of further regulation is about getting better information. Private equity investors as a whole are very sophisticated. Probably the most sophisticated investors in the country are the ones who have access to these private equity funds. Maybe that's what it's really about, is regardless of who has access to the funds. But what I'm reading about proposed rulemaking around PE is more about structural PE and limitations on what sponsors can do, how the promotes work, how the fees are paid, when to get the fees. I mean, it's not stuff that gets to disclosure. It's more about how do sponsor funds actually work. That doesn't sound consistent with the way you're describing the other stuff to me.
Yeah, and I, like I said, I think there are parts of the rulemaking that are, like I've said, structural or plumbing related. And, PE, to me, the headline item was, you're going to have to tell us more and more frequently than you did in the past. But you're right, there are parts of it that do, I think, try to address what are perceived as sins or problems or inequities of information and control amongst those sophisticated investors, to try to eliminate, even rich people deserve a fair playing field, I think is the idea. But like I said, I think that's what I put, that's where the minds can differ on how the value of that rulemaking is. But on that specific one, I don't really have any, because in all honesty, I don't see that as from an enforcement standpoint, unless it causes a broader market harm. Sure,
Yeah.
but I guess one of the things is, so they are very sophisticated, and is it and I guess that I would put the question back of, is it that we got to share this information, or is it that it's really expensive to share? What is the fear? Is the fear that, well, if we give these people this information, they'll never want to, they won't realize what a bad deal they're getting once we give them this
I'm not
information.
sure I see the rulemaking going so far as, or only so far as information, but more to control plumbing.
Right.
Right. And how sponsors get paid, how sponsors earn their promote back into the deal. And, in my mind, if there's disclosure of all of that to the investors and investors invest, well, okay, great, everybody's on board for that. Right. But it feels, when I read the press about it, that where the commission's going is, we don't like that as a practice. We want to stop that. Right. It's not about, maybe that's just one man's reading of it.
Right.
Although it's shared by a bunch of partners, but it's several people's reading.
Right.
I'm just curious, it feels like all of this regulatory stuff also has an undercurrent of, and we all know, there's a different administration. It's a very progressive.
You can't, you can't divorce the change in administration from the rulemaking, but in terms of, I don't know that I have anything to add. That may be a valid comment. And it may, like I said, where it intersects with, say, the enforcement of those rules, I just question, what is, thinking about it for the enforcement attorney, former enforcement attorney, is that really where I'm going to go spend my time, my limited resources to help, a sophisticated investor who may have somehow been harmed indirectly by private funds failure to follow these particular provisions? I think that's the reality. Now, what that means from a, like a compliance and supervision, that's probably a different question, but I don't really have much more to say on that.
So we're going to save 10 minutes for questions. So you'll have to ask questions. Thank you, John, for that question. And so Why don't we though, what I want to understand is we give you a break, David, a little bit. So for each of the others though, what do you tell, what's some advice you're giving your clients now that based on all the stuff, all of the rulemaking that's going on, say a different administration that's probably more aggressive and willing to take cases that it wouldn't have taken before, but maybe not going to be convinced by precedent, for instance, Steve. So give me, what do you think right now would be some good advice in this environment?
Well, I tell them get the
For free.
basics right, right? So don't trip up on the stuff you know you're going to have to do to even be in a conversation around cooperation. Appreciating you're taking accelerated risk because you have incomplete information. So it's like put yourself in the best position to be in an advantageous position to present that argument, right? And there's some just blocking and tackling. Don't mess up the blocking and tackling, low-hanging fruit, right? And it is an evolving regulatory environment, right? Focusing on different things, some progressive, some not. And so, but if you don't get that basic stuff right and make those decisions timely with the information you have in good faith, you aren't in the conversation for things like cooperation or a better posture. So it's like, don't try to start by looking downstream at the refined points. Start by getting the basic things right. Right. And putting a process in place, informing your board, let the different, because the whole securities apparatus is intertwined, right? So the board has a role, make sure they're doing their role, right? Inform them, right? Make sure they, if it's, depending on the nature of it, auditors are informed or whoever they else, right? Do those basic things that you have to do to put you in position so you don't create or lose the opportunity to create value downstream for the client.
What about precedent? We talked about that a little bit before this. How persuasive is that? Because I know in accounting cases in particular, these great tables that you could look up and say, well, I have a CFO,
Right,
committed a 13A, 13B2 violation, whatever you want to make up. And this is the range of settlements. And you go into the SEC and you say, here's the last 5, give me that. Does that work?
no, I just did that. It did not work. Right? And they were not shy about telling me that's, appreciate the thought, understand where you're coming from. We disagree.
I'm getting so much of that right now, like so much professional courtesy and just nothing else.
Yeah.
Yeah,
Well,
I think this-
Brutal on every kind of investigation.
Well, and I think now precedent is almost seen as, yeah, that's what we did before. And here is your client, hypothetically, not mine, saying, they did the same thing. So clearly our previous penalty or precedent was not enough. And
That's a fantastic
Which is
point.
a
That's
great,
also, yeah, that is 100%
punch
right.
counter punch.
I mean,
guess.
it's kind of how I
Is it
parent.
though?
But
Is
yeah.
it though that we penalize somebody and that didn't deter everyone from ever doing it again?
Yeah.
That's not,
Yeah.
that doesn't seem, it's a good point, but it's like,
Especially when it's non-scienter,
yeah. I
strict
mean,
liability triple.
But I think you need to assume that is how it is being viewed on the commission side, and you need to explain why, maybe not by flat out saying that's a bad approach, but by saying why, why you're different, why, the company took its responsibilities very seriously, but here's kind of what happened. And now they've, fixed that area. I mean, I think you need to approach it from the standpoint that there are cases out there saying this behavior is, bad and we've charged it. Somehow it happened to maybe at our company anyway. How can I present this in, a different view, a different angle, just kind of try to, package it up as best you can, because the precedent argument is no longer a convincing one. Which kind of gets to what my, I think, advice is right now on a lot of things. It's been interesting, I think, because the SEC has been active in the rulemaking, because they're active in the SPAC space, a lot of corporate partners are reaching out kind of at the deal phase to me and saying, we're assuming the SEC is at some point going to look at this. What should we be doing now to, document things correctly, to make things, look good later, which is, I mean, I think a fantastic thing to do. And I think, that's exactly what a deal lawyer should be doing, because a couple hours invested talking to a litigator or a securities enforcement attorney, pre-DSPAC or immediately right after can be really beneficial, because a lot of what we talk about is, the ones I talk to, I mean, our clients, our MACM lawyers, they are trying to do the right thing. The problem is 6, 9 months, a year later, an SEC and enforcement attorneys looking back on it, it's hard to recreate that story. The DSPAC timeline is fast. The emails are going back and forth quickly. The diligence questions are being maybe asked in email but answered on the phone, and so there's no document, looking back saying, no, we really did chase that down. Whereas maybe I, as the former enforcement attorney, am like, they asked a question and no one answered it, and so I think doing what you can do to be circling up your diligence docs to show that you tried to run down these statements that were being made, documenting them as best you can, it lets you present a package and a story that is complete to SEC staff potentially later. It doesn't rely on memory, which is already, mine is already terrible. I'm trying to remember what even happened a week ago, or through testimony of, well, did you have a phone call after that email? No idea. And so I think the more you can do to document your process, the better.
That's good. Good.
I'm telling companies what everybody else is telling companies, like sort of like what you were talking about. Just make sure you're assessing your risk matrix and blocking and tackling the things that you can control, right? So do your annual training. Make sure your board is aware, and in the conversation about where your risk really exists. Understand insider trading and make sure that you understand what your own policies and procedures are around that. That's just bread and butter. And it's incredible to me how many times I find myself having that same conversation over and over and over. And then when something does go wrong or may have gone wrong, I think the idea and really understanding what is meant by the idea of cooperation and self-reporting always needs to be in the conversation. Not that that's the decision that's ultimately going to be made, not that that's the right fit, but if that is a stop on one's journey through enforcement, you have to be getting it right from the very beginning. And that means something very different today than it did even a year ago in terms of a full company shakedown, right? And really scrubbing the facts and who your independent counsel is for the investigation, right? Commissioner Crenshaw, or I think it was Commissioner Crenshaw last year that talked about not so independent investigations. So really from step one, you have to be thinking about where you might end up and how to prepare yourself, your company, your client for the best possible outcome, and recognizing that cooperation doesn't mean, you did what was asked and now you want no action. The enforcement staff is, you could say aggressive, you could say active, they're doing their jobs, right? Enforcement staff work for many years under a lot of different administrations. They become very fluent in the rules and they're trying to get it right. And sometimes that means.
Are you just saying that because there's some here?
No, well, in part, yeah, because I don't want them to jump me in the parking lot, but also because that was my job and it's a hard job. And it's often a thankless job when you have opposing counsel sitting in the room telling you all the reasons that this company that allegedly committed fraud should not have any action whatsoever. Reasonableness must be a component of the conversation about cooperation. And that means getting on the defense side, getting your client comfortable with how the world truly operates. And it operates a little bit differently right now. It operated a little differently a couple of years ago. It might shift again, but right now, a company has to go in being self-aware and understanding where things went wrong and really being willing to have a conversation about that. And if you're not, you should not expect any form of cooperation credit. You really shouldn't even expect goodwill coming back because the staff are very busy. And I'm not saying that as an apologist. I'm just saying that because you're kidding yourself if you're thinking
you need
otherwise.
to know that going into that conversation. It's exactly right. I think it's getting your client to understand that. Obeying an issued subpoena is not cooperation. That is following a subpoena. Cooperation is going above that. It is either conducting that deeply thorough internal investigation and bringing additional facts to staff. It is self-reporting, which is something that is done before you're filing an 8K or press release to the market. That is not a self-report, at least not now.
And that can mean having very, very hard conversations, right? You don't get paid the medium bucks as outside counsel to always have easy conversations. I'm not like a woodcock at Jones Day, just printing money.
I'm not at
Oh, I remember when you were my friend. I got those bills from you. But you have to be willing to have the hard conversations about this person has to get the hell out of your rep chain, right? John Wander and I have had these conversations about how are we going to take this company through this conversation about what really went wrong, because they don't want to confront the fact that Something did occur, a person did go rogue, you're gonna have to talk about it in your public filings. That's life, man. The sooner you pull that Band-Aid off, the sooner you can get to the other side and start healing the wound. And you need a lawyer willing to have those hard conversations and then step back and say, for instance, in an investigation, I was the investigator. I'm here to help steward you audit committee or you management through this investigation. I'm not going to turn around and go be your advocate. I can't do that. Which, is another hard conversation, but that is how you get it right. It's really not that hard, but it's hard for companies because they're spending money and they're losing reputation.
Well, to that point, it's the timing of remedial measures. So it's the last two paragraphs before the actual sanction. You're trying to get those last two paragraphs, right?
Yeah.
It's so 100% right about get them out of the rep chain. And you have incomplete information when you're doing it, right? So you're doing it and you have to do it faster now than you ever have.
Yeah.
So it's the remediation and enhancement of the controls or the issue, root cause it, you got to remediate it even when you're not 100% sure.
The proactive remediation. It's not the remediation at the time of an enforcement action recommendation saying, oh, you're going to sue my CEO. I guess we'll remove him.
Right.
Like that's not remediation.
You don't get any credit for that.
No.
Right. In fact, that goes the other way around. Saying your governance process didn't work, right? Because otherwise you would have done something earlier.
So, David, there's been lots of talk about what you should do to get your clients to cooperate. Good advice. What do you think about you and I talked about this so many times. I learned a lot from you, frankly, about cooperation and what it means. What does it mean in this environment?
I mean, I think Jessica said it, they've all said it, which is you've got to go beyond merely responding and doing what, frankly, any average person would do in the situation. It's it's easier to maybe define by example. There have been cases that we have had where the cooperation went to the point of counsel, showing us, walking us through the transaction lines and helping us understand exactly how a transaction that was problematic occurred, how it went through the books, who said what, who did what, really walking us through their thinking. And kind of an implicit, if not explicit acknowledgement, yeah, this was not right. Giving access to, if you've got experts in your company, giving us access to talk to those people about the transaction and not in response to a subpoena, but you're basically educating the staff and bringing us from knowing nothing about this case to knowing virtually everything about the case. And you can go on down the line, and you'll be, one thing I'll be clear, it does not entail giving up privileges. Although, I mean, that seems
You don't
to be,
mind when we do.
well, I mean, you make a strategic decision, right? You make a decision that can be a factor. We go, wow, they did, but does not entail that. I can think of a case that I think David probably remembers, ArthroCare, many years ago. He was on the other side of it, but the cooperation we got from the company was, in my view, exceptional. And we even noted it in the order that we filed, or the agreed order that settled the case with the company. Now, I will say DOJ did not agree and actually prosecuted the company, but that's DOJ. That's not us.
That was a twofer. That was a good way to say we're not DOJ.
Yeah.
But the point is, the tone that they set in the initial meeting was, we're going to show you what happened. Basically, we're understanding that something bad had happened and they weren't trying to soft sell it. And I think that's the key. We're not stupid, all appearances aside. To the contrary, we understand when something bad has happened. And if you come in and tell us there's nothing to see here, well, you've lost credibility. Your client has lost credibility, and we will hold it against you. I mean, in the sense that we won't give you credit going forward. And something that happens early, it's really hard to undo that by the end, and so that's something, like I said, day one, I encourage companies and their counsel to come in and let us know what really happened.
Especially when you could be sitting on a whistleblower report also that gives you more
I
information.
think
I mean, that really
yeah.
blows credit.
I mean, I think it's now, look, I understand if you don't think really don't think anything illegal happened, and you can walk us to that. And we've had this conversation in your current role, not in your prior role. it was legitimate. I mean, come in, show us, you walk us through everything. We go, you're right. There's nothing to see here. We move on. And I've had it go the other way. I remember many years ago sitting in a conference room in our office, and special counsel comes up and shows us all these horrible emails of what the horrible things that happened in the company. And they turn off the projector and say, well, we did not see any evidence of any intentional wrongdoing. And I mean, literally the then head of enforcement, Spence Barish, basically said, I think this is another Enron. And so, I mean, right off the bat, that company was starting in a deep, deep well of lack of credibility with us.
So don't do that.
So don't do that.
So we don't have really any time left. I don't know. So anyone have any questions?
Oh, and I'll say on the questions, I'm getting real-time feedback on this panel from those watching remotely. Everyone's doing great.
Fine.
Please repeat the question because they can't hear. They don't have mics in the audience.
Does anyone have any questions I can repeat? Yes.
I want to go back to the private equity conversation, if you don't mind. I want to really hit on the point that these proposed rules seem to be going really far beyond regulatory actions here, and that it really seems to be trying to get at an economic agreement between two very sophisticated parties. And so one example I'll give of that is the proposed rules that say you can't have an after-tax product. Well, from my perspective, that just means the next fund that I raise, I'm going to say, okay, our clawback is only going to be 75%. We'll just make a different economic deal with our investors if they want to invest. Great. Is the SEC going to start going after economic arrangements and continue to press on that point? And so, what are they trying to get at? Given to the earlier point, you have two very sophisticated parties in private equity.
I don't know how I'm supposed to repeat that question. I will say, defend the private equity rules again, David. Because they are
And I don't know that
indefensible.
I don't know that I can defend them. I mean, they're written out and the rationales are, the rules are stated as they are. And I think there is going to be pushback on how a fund works and whether its relationship and how it interacts with its clients, whether that's the right place for regulation. I think what has driven some of this, I don't know if this is exactly the situation here, is concerns about conflicts, concerns about all manner of conflicts, not just side letters, but I mean, all manner of conflicts that just don't get addressed, or because of an imbalance between this party and the fund. Like I said, I think that is what's driving it. And the symptoms are specific things like that. Now, whether that's the right thing for us to regulate, I guess we're going to find out in the sense, the comment process, whatever litigation process follows, how we actually apply this in reality. Those things will probably get more sorted out. I know it's not really much of an answer, but it's put there, and the drivers, I think, had to do with what we see as inequities or improprieties that lead to bad outcomes. Don't have to agree, but that's what the rulemaking is driving at.
Does the Division of Enforcement have like an ombudsman to the rulemaking process on the front end, like through OTC or I mean,
They're enforcement
chief
people assigned to the
counsel?
rulemaking teams.
Yeah, there are parts of their teams that write these, yes, but not like an ombudsman for
Yeah,
all
yeah.
rulemaking that I know of.
They'd be too busy. They couldn't do
Yeah.
it.
Yeah, not now. Yeah, for sure.
Anybody else? Oh, yes.
So I will ask a crypto question, and we'll start from the premise that Howie has not resolved all the issues before the SEC involved in crypto right now. And if it really were that clear, then I would think the SEC would have moved much faster with regard to the hundreds of thousands of ICOs that have taken place that have not been acted on. My question really is for clients right now that are in broker-dealer space, they're in exchange spaces, where it seems to me, reading between the lines, reading Gensler's speech last night, the commission is fully intending to move to regulate them, and yet the industry still believes that there is no precedent for that. And there is precedent, small little moves, but I guess my question is in two parts. I know you're limited what you can say, but can you say anything about the commission's trends towards moving there? And then more specifically to clients, the orders I've looked at, the enforcement actions I've looked at, and I think I may just be listening to what I want to hear from the panel, but I keep hearing we're going to bring Chapter 13 cases when we also see fraud matters. And when I look about a lot of the orders that have been brought that really are just compliance cases or process cases, there is a fraud in the background that may or may not have been formally named, but it gets written about. So am I okay telling my client, as long as you are not engaging in some misstatement, misrepresentation, fraud, you may have a process violation, but you're not likely to be at the front of the line when the SEC decides to start enforcing broker-dealer cases, enforcement exchange cases. Too much.
Well, let me see if I can summarize the question.
Okay, good. Because I was.
But
gonna do it
I
in probably
think
a way
if,
that was.
if the answer, if
wouldn't
the
have liked.
question as I'm interpreting it, if you're not committing fraud,
Yes.
is the SEC still going to be looking at you? Is that,
I don't mind you looking at my clients.
or bringing an enforcement action? I mean, well, bring an enforcement action. I mean, I
encourage
think,
you to look at it. That's good business development.
I think the answer, and I think if you look, the vast majority of the crypto and market related cases are non-fraud. I mean, there may be some, I haven't done a survey of every of them.
Registration is the game. right? I mean,
Registration,
That is the game.
Section
Yeah.
5, and then for the exchange, for exchanges, somebody will remind me on this panel. But for the unregistered,
Yeah, 15.
I think that's right. So those are the cases that we have brought to this point because they are not, I mean, because that's the violation we're seeing. And if we saw fraud, we would bring that case too. But I think by and large, at least, I'm assuming, these aren't my cases. I'm going to go by what I'm reading, that the charges are based on the registration or lack of registration element of the activity. And if we, but if we, I mean,
I think
but why
that,
wouldn't we bring, so you say
Because I
we
think-
aren't bringing fraud cases in
Yeah.
this area?
I think that I think that the staff looks at a lot of businesses that are, mining or ICOing, whatever the business model is in crypto, it's looked at with sort of the raised eyebrow, like that's the starting point. There's probably something wrong here, I think is how enforcement starts. When, I don't think that's a fair start, but I think that is the start. And, let's see what we can find is sometimes the approach.
I mean, again, I haven't run one of those cases, so I'm giving you what I see, and my view of it is, I think it starts at the other end. It starts with what we have been really focused on is the registration elements of it, and where we see that something more, we have brought fraud cases. But I mean, my sense is, why wouldn't we bring a fraud case if we have evidence or think we have evidence of that? Because we're going to have to fight the same battle on whether it's a security or
Well,
not.
because there's the precedent for what is and is not a security, favorable district court precedent about what is and is not a security in the digital asset space. Whereas the nature of evidence around digital assets is sometimes ephemeral and harder to put together a prima facie case to go get a temporary restraining
Okay,
order
well,
and an
that's
asset freeze.
different.
So
Yeah.
let's get a Section 5 strict liability and we can probably put these guys out of business
Yeah.
or at least put them on the curb, whereas we wouldn't be able to get
I see
across
your
the finish line on a.
Yeah,
on a fraud
I think your
case.
point is probably a little different. Not that we wouldn't bring it, it's just that the evidence that we can marshal to support a case isn't there, or
could be
it's
a lot
very
harder in
challenging
that
to
space, yeah.
obtain. Okay, I can see that. Yeah, I can see that.
Get
But I
that,
think
if you
where
write, if you do
where
it
we
right
have
up,
been,
McGee 1,
is-
Peebler 0.
I want to see the larger tote board on that.
Yeah, me too. Me too, man. I'm not gonna come and strike that.
But I think ultimately,
he has the power right
we
now.
have been really focused
That's true.
on the registration elements of those particular, in that particular field.
So we're done, but I think the panelists will be here for a few minutes afterwards. I want to thank everybody for doing this. They were great, very engaging, very esteemed panel. Thank you, David, for doing a great job representing the agency and often defending what could be only described as the indefensible. But no, really great
Oh, to
job.
be the
everybody.
moderator and get the last word.
Thank you all very much, and thank you for hosting us, Vincent Elton.